So I still do this, and I love doing it. And that is, I talk about how the defense in this case has refused to accept personal responsibility, which is one of the biggest themes there is. He's refused to accept personal responsibility for their actions in this case. So it's going to be your job to place responsibility. They've refused to accept personal responsibility to the extent that they have filed with this court papers in which they claim this is the responsibility of the plaintiff. It's the responsibility of third persons unknown. It's the responsibility of, it's an act of God. An act of God. So I'm going to listen very carefully with you to this evidence about what act of God caused this intersection collision. What act of third persons caused this? So it just goes, and then of course, that's coming out of their pleadings. They can't really support it, and they end up with the same thing. At the end of the day, you've set up your summation for who's been honest with you in this case. And in the act of God, in serious injury cases, when they do plead the act of God, I'd have my, we did one not that long ago where we had a lady testify that what had gotten her through these devastating injuries was her faith in God, which is very true. She's a very religious lady. Her faith in God, which gave her the courage to go on. And her belief in the jury system that someday she would be able to have the additional medical and so forth that she needed. So I was able to say, there is an act of God in this case, but it wasn't in causing this tragedy. It was in giving this woman the strength to get through it. So that's what I call thematic reversal. And it's lots of fun. First thing you do is figure out what their theme is and then figure out how you can turn it against them. If it's a clear case of liability where they can't, I love to, at the end of my closing, the opening part of my summation, I love to put up on the board the amount of my damages. We open fully, so we have to put all of our damages up in the first part of the closing argument. So I put the entire amount of the damages up, and it'll total $5,482,612. And then I'll say, now, ladies and gentlemen, this is what the evidence has supported. At least this amount. At least this amount. But if counsel disagrees with this number, I would like to have him come up and tell you right now, because I'm going to sit down now, let him come up here and tell you right now what is the reasonable value that those of us in our society place on the life of a child. And then the defense lawyer has a dilemma. He can, if he goes up and tries to put any number on it, if he puts a low number on it, $250,000 for the death of a child. If he ignores it, then the way you've set it up, you can stand up and say, well, he obviously agrees with the number, because I said if he disagreed with it, he should put up a different number. You can only do that in clear liability. If it's not clear liability, they'll just walk up there and put a big zero and then go into a discussion of causation. How do you get into the discussion of damages? I don't talk about $10 million or $5 million or $100,000 in voir dire opening. I have a simple technique that I learned from a great lawyer named Pat Maloney in Texas. He would stand up and he would say, ladies and gentlemen, this case involves millions and millions of dollars. And would you be able to return a verdict if the evidence supports it? Can you return a verdict for millions and millions of dollars? And so Tommy Malone, I don't know if Tommy Malone is the best, most effective plaintiff's personal injury lawyer or not, but I'll tell you that the class he's in, it doesn't take long to call roll. Tommy called me. He was getting ready to go to a trial, and he says, you know what? I've been familiar with the case all along. He said, I'm going to ask him for $25 million in this case. He said, I don't know what I should do. And I think it may be worth more. I said, well, why don't you do what Pat Maloney did? Just stand up and ask the jury, tell them it's about millions and millions of dollars, and at the end of the day, you can argue it in summation. So he did. He went for millions and millions of dollars, and the jury awarded $49 million in that case. So you got to leave yourself room for error by not making any errors. There's another defense they use of throwing everything up against the wall and see what sticks, and where they'll just they confuse, they muddy the water, and when we have the burden of proof, simplicity is our friend. So I tried a case against the Kodak Corporation, and they came in, and the judge, we were in federal court, and the judge asked, a juror asked, the judge said, do you have any idea how long this is going to last? So he said, I don't know. And he asked the lawyers, he said, how long is this going to last? And fortunately, he asked the defense lawyer first. They said, 15 days, Your Honor, 15 days of testimony. And he asked me, he said, Mr. Nations, I said, well, I have a very simple case, Your Honor. We can put it on about 3 hours. So they had set up literally 16 feet of equipment was set up in the courtroom for all these demonstrations that Kodak was going to do with all this heavy-duty equipment. So anyway, I used one of my very favorite techniques. It's called a running metaphor. And this is what I use. When I know they're going to muddy the water, I set them up for this. But this just doesn't just apply to closing. It applies across the board. You start using it in voir dire examination. But since I was in federal court, I didn't have any voir dire examination. So in this particular case, I said, what? Because the juror, the prospective juror who was trying to get off says, why is it going to take 15 days for them if he's only doing 3 hours? And he said, well, he was smart. He was trying to get off the jury. So I answered the question. In opening statement, I said, I'll answer the question. My theme was, this is a very simple case. We prove A, then B, then C. That's it. That's all we have to do. Now, the defense in this case is employing what is commonly referred to as the Octopus Defense. It's a standard technique of the defense. And of course, you can always throw in the old bromide about, if you have the law on your side, you argue the law. If you have the facts on your side, you argue the facts. If you have neither the law nor the facts on your side, you use the Octopus Defense. And the Octopus Defense is this. When an octopus is under attack, in order to extricate itself from its situation, it swims away and it squirts very dark black oil into the water in order to blind the eyes of those of its pursuer. The defense is using that defense in this case, the Octopus Defense, because what they're going to be doing, the reason they have all this equipment set up here, and the reason it's going to take them 15 days of testimony is because there's going to be 15 days of confusing evidence that they're going to try to bring for the simple purpose of squirting dark ink in your eyes. My job and your job is to keep your focus on A, then B, then C. That's it. Everything else is just oil in the water. So then as we go through, I put my client on the stand and we're testifying. It's a contract case. And he's testifying. I'm saying, okay, you heard the opening statement of defense. Now let's see if we can clear some of this oil out of the water. And ask him a question about it. And then on cross-examination, use the same phrase in cross-examining their expert. And then in closing argument, after their defendant's argument, I was able to say, not since the Exxon Valdez has there been so much oil released in such pristine waters. Now, let me tell you, this was great. We obviously got a verdict or I wouldn't be talking about it, but after it was over, we're talking to the jurors. We only had 8 jurors. We were in federal court. So after it's over, the jurors stayed and talked to us. And they talked for a long time. And so they're asking questions of us, and then the defense lawyer, great defense lawyer, great guy, but he pops in there and he says, yes, but what about the foreperson of the jury was given an answer, and he says, yes, but what about this? And she said, oh, that's just oil in the water. So that was one of the first times that I actually could prove that this bullshit I tell you actually works. So the defense in malpractice cases always likes to, they always come up with a say for all. They'll say, yeah, the standard of care that the plaintiff says is right. Yeah, that's standard of care. But there's not just one standard of care. There are several ways to do things. So then they bring in all their friends to testify. There's another standard of care, and it just happens to be the exact one that this defendant employed. So what I like to do, and I started as a defense lawyer, and I had the biggest mess because I had a doctor who was on duty. The other doctor who was supposed to be there was out that night. He didn't come in. So they brought this child in. I'm going to tell you this very quickly. They brought this child in, and the story was the child was brought in. They had symptoms. The doctor came in, looked at the child. Then they brought in a multiple injury accident case. This doctor had to run out and see this one. Then they come back and look at the child. Okay, do this test. Then they'd go out and do, and it was just a picture of total chaos. A picture of total chaos. And in the end, the doctor sent the child home. And the child went home overnight. They missed the diagnosis. The child went home overnight, and they brought him back the next day on an emergent basis, and the child died. So I'm looking at defending that. So the way I defended it very quickly was this. I put up on the board, I said, okay, what are the tests that you do, doctor, when you... what are the tests that are required when you presented these symptoms? A, purpose of A, did you do A? Yes, boom. What was the result of A? Negative. B, C, D, same thing. Did you do all these? Yes. Is that the standard of care? Yes. Now, did you do anything else? Yes. This hospital happened to have a new equipment that other hospitals did not have. Tell us what that is. What does it do? Did you do that? Yes. What was the result? Negative. Okay, so you've actually gone above the standard of care. Yes. Boom. They brought in a verdict for the defense, and which was probably the correct thing to do. I'm thinking when I get on the plaintiff side, how do I overcome that? And this is one of the most important things I can tell you, which is about the power of choice. The power of choice. You always, regardless of what type of case it is, one of the most powerful things you can do to set up your argument is to think in terms of how many different ways, how many different things could the plaintiff have done, or could the defendant have done, which would have avoided this result. Not just standard of care, but in an auto accident case, the defendant was driving too fast. The defendant chose to drive too fast. The defendant chose to drive in excess of the speed limit. Choices. The defendant could have driven more slowly. The defendant could have turned to the right to avoid the accident, the left to avoid, all sorts of things. So you put down in a product liability case, how many different designs were there? How many different ways could this have been done? In medical negligence, how many different ways, not necessarily standard of care, but what choices did the doctor make? And remember that doing nothing is a choice also. And so the more choices you can put up that the defendant was supposed to have done that would have avoided this accident, there gets to be an exacerbating effect from it. And the exacerbating effect really is important because that leads to increased damages. The next thing is a last thing I'll mention here, and then I want to do a very brief demonstration for you, is attribution. The attribution, two theories of attribution. The first is purposive attribution, and the other is reactive attribution. Purposive attribution says that if a jury decides that a person acted on purpose, not intentionally, but what's the difference? That they acted on purpose, okay? In other words, the defendant chose They purposely decided to drive 70 in a 40-mile zone. They purposely decided to make that red light. They purposely decided to do whatever it was. If they acted on purpose, the jury will tend to not only find negligence, but punish, not punitive damages, but award more damages. On the other hand, the other side of purposive is reactive attribution. So if you can attribute the conduct of the defendant to reaction, they will actually even forgive, maybe even the negligent acts, if you were reacting to conduct from the other side. We are almost always in the position where the defendant acts and we react. So you want to stress to the jury that this is purposive conduct. They chose to do it this way. And the conduct, we ask you to examine closely the conduct of the plaintiff, because they're going to anyway. And then ask you to review the conduct of the plaintiff in the context of they were reacting to what happened to the defendant, to what was caused by the defendant. So if you can set it up that way, you have a much better opportunity.